State of Tennessee versus Jaylen Lobley, case number 240-03789. Here for a bail hearing. The defendant, Mr. Lobley, is in the courtroom at this time. He's represented by Mr. Garcia. State of Tennessee is represented by Mr. Walker. Mr. Walker, Mr. Garcia, how do you all like, would you all like to proceed? Any opening statements at all?
I don't have any opening statements.
No, sir, but I was the first one to see it.
Okay. All right, Mr. Walker, you may go forward.
All right, the state versus Mr. Lobley, I'm gonna mispronounce his name. Lobley.
Just one, Mr. Walker. How do you pronounce it, sir?
Lobley.
Mr. Lobley. Okay, thank you.
In the short of the theft of property, 10,000, it's time two. These felonies, unlawful carrying or possession of a weapon, key felony, prohibited weapons, containing guns, ones that is felony as well, vandalism, 1,000 to 2,500. Mr. Live there, right? Mr. Lobley, is currently a $10,000 bond that's set. I really don't want to see Mr. Lobley behind bars, but his next court date is tomorrow. If I'm not mistaken, is that correct? It's tomorrow. $10,000 bond. I don't think anything would make a difference. Mr. Lobley's mistake was that he admitted to everything. I don't see him as a flight risk. I don't see, there is no victim, so I don't see any intimidation of any victim or witness. I can't attest to his length of residence. I can't attest to his employment status. He's 18, so there will obviously be no prior criminal record as far as adult court. I can't attest to his juvenile record or bring that up. The nature of the offense, like I said, the nature of the offense is high likelihood of conviction. Like, they admit to everything. 2 stolen cars, 1 Infinity, if I'm not mistaken, which they found him in sleep, and 1 Charger in the back, which witness said that was stolen, or the victim said it was stolen from her. So I do mistake, there are 2 victims. And then when they being the officers got him out of the vehicle, Glock came out with the Glock switch on it, which, like I said, the office and the city takes pretty serious, both vandalisms, theft of properties regarding cars, and especially Infinities and Chargers, and Glocks with switches on it. Like I said, the bond is currently $10,000. It was a fairly low bond, really, given the circumstances. Being that his court date is tomorrow, I don't see any need to adjust anything. They can resolve this in the court that is set in 12, if I'm not mistaken. So my suggestion would be to keep it the same, but if the court is inclined to lower it, I won't be upset at that. Like I said, I want to see him here, but this is not, we're not making any determinations of any sentencing up here. It's just strictly about the bond. So like I said, being that this court date is tomorrow, I see no need to do anything with the bond.
All right. Is that all, Mr. Walker?
Yes, sir.
All right, thank you. All right, Mr. Garcia, you may go ahead.
Your Honor, we're talking about a non-violent 18-year-old about a property crime with no violence involved. Your Honor, he is a resident of Memphis, Tennessee his whole life. This charge, even though the likelihood of conviction is high because of his confession, we also have to consider during bail his likely sentence. He's 18 years old, he's young, he's rehabilitatable, and it's possible, I'm not sure how likely, but I think highly likely that he might get favored. And if that's the case, I think that that's something that Mr. Lobley will be able to do, and he'll come back to court to take that offer. And of course, we're talking about his risk of life and his state of the community. There is no record, no adult record on Mr. Lobley. There's nothing to judge his state of the community. There's nothing to judge his risk of life. Well, there is. The lack of failure to appear shows that he's a like to come back and forth. I understand that he's 18, and that can explain for the lack of NDAs or anything or any other context with the court. But as it stands right now, that's what the evidence says that is still here. I would ask the court to do the full analysis, starting with presuming that he is RORable. It's not RR conditions, and we have to set a money bail bond, Your Honor. We're asking for something that Mr. Lobley can afford, and for that, that's $5,000.
So a brief rebuttal, I would state that I don't want to get man on again. Mr. Jaylen, to program these keys that you don't learn that in a day. You know, it takes a little second to know how to learn to do that. And steal 2 cars, it's not something you just wake up and just decide to do. Like, you know, so being 18 and having nothing on your criminal record, that's, like I said, that's something you throw out. You can't throw it out, but something you throw out the window. Me speaking physically. Like I said, the court date is tomorrow. I can't speculate to what the offer will be, what the charge will be. Defense counsel speculating this might be this, that, and the third, but you're sitting on a few felony charges. So, like I said, they can be resolved in court. Court date is tomorrow. So, getting out today, posting the bond today, that's a waste of money. And so, looking out for his family and looking out for him, that's just a waste of money to do that just to come back to court tomorrow. So that'll just be my brief rebuttal.
All right, give me a moment. Mr. Garcia, I know you mentioned, Mr. Lobley's residential status. Could you just repeat that for me? I want to make sure my notes are correct.
May I ask my question?
Or did you made some statement regarding,
Yes.
you can, but what did you tell me during the,
He's a
during
resident
the?
of Memphis, a lifelong resident of Memphis, Tennessee. I don't have my file in front of me, so I don't remember the address.
Okay, that's fine, I don't need that, but he is a lifelong resident. Okay, thank you. I thought I heard you say that, but I just wanted to be sure before I went further into my analysis. Is he working, Mr. Garcia?
At the moment, it's not, Your Honor.
Okay. What about the previous month?
I don't have any employment history, and I can read that to the court.
All right, thank you. All right, I'm ready to get my ruling. All right. Pursuant to 40-11-115, as the magistrate, I am required to first consider whether this defendant is a candidate, in setting bond, whether this defendant is a candidate for a release on his own recognizance. In making this decision, I must consider the 7 factors listed under 40-11-115. The first being the defendant's length of residence in his community, representations of counsel which were not objected to or impeached in any way, or that the defendant is a lifelong resident of Shelby County. Secondly, the court must consider what the defendant's employment status. In this case, we do not have a record that the defendant is employed. Well, I'll go over those that don't weigh in his favor, and then I'll go over those that do weigh in his favor. First, the court must consider whether the defendant is employed. The representation of the testimony adherence that the defendant is not employed. Additionally, the court, as was pointed out by Mr. Walker for the state, the nature of the offense, the apparent probability of the conviction, and the likely sentence can be considered by the court in making this decision. The testimony and from the affidavit itself is that the defendant admitted to these facts. However, the court shall consider these factors insofar as their relevance to his risk of non-appearance. In that regard, the factors that weigh favorably for the defendant is that he has not, does not show to have any failure to appear, that may or may not be due to his age of 18 years old. However, the court must consider what is before the court at the time the decision is being made. Additionally, the court should consider whether the defendant has a prior criminal record, which the defendant does not, and he is not released on his own recognizance or bail during the time this particular offense was charged and or committed. There's been nothing presented to the court with regards to any substance abuse or mental health issues that the defendant may require. In addition, there's no other factors indicating the defendant's ties to the community or his risk of failure to appear. So quite simply, what I have is a defendant here, pursuant to 40-11115, who has lifelong ties to this community. He has no, as admitted by the state, there is no apparent flight risk. The other consideration for the court would be the safety of the community. This defendant does not have any prior convictions, and as such, there is no basis for the court to find that he is a presents a risk of safety to the community. So for those reasons, I'm going to find that the factors on the 40-11115 when appropriately weighed, do weigh in favor of an ROR, release on recognizance. However, the court is going to, I'm going to set it for an ROR at a level 5. Additionally, Mr. Garcia, I'm going to require a curfew for your client. I'm going to set it at an ROR level 5 with a curfew of 6 a.m. from 6 a.m. to 6 p.m. unless Mr. Lobley is traveling to or from school or work back to home, and vice versa, home to school or work. And that would be for work, school purposes only, 6 a.m. So let's say it this way, 6 p.m. rather to 6 a.m. He must be in by 6 p.m. Cannot come out until 6 a.m. during those hours. And Ms. Garcia, I apologize. Speak up for me. The air conditioning is right above me.
I apologize for not mentioning this during the hearing. He has a son. He just told me that he picks him up at 8 sometimes.
8 a.m. or 8 p.m.?
8 p.m.
And Mr. Lobley, I'm going to go ahead and advise you, just let Mr. Garcia, he's a skilled and competent attorney, and you do have some rights, sir. One of those is the right to remain silent. So I'm going to go ahead and encourage you to utilize your attorney at this point, sir. All right, go ahead, Ms. Garcia.
Your Honor, we're asking for a later curfew just so Mr. Lobley is able to pick up his child. And that should have been mentioned during the hearing as it does, is relevant, but that agreeable to the court.
When we say 8, are we saying 8 a.m. or 8 p.m.?
8 p.m., Your Honor.
Okay, I need to know a little more. Pick him up from where and for what?
May I speak to my colleague?
Yes, sir.
So he has a job and goes to daycare in East Memphis. They close at 7, but he's worked it out with the teacher there where he can come at 8, they can pick her up, and he will be at home by 8:30. It's 8:30 or 8:45 to 9 o'clock, and agreeable time for work.
Under the circumstances, Mr. Garcia, I am going to find that in weighing these factors, again, I've gone through my analysis as to why, in accordance with the law, RR is reasonable under these circumstances. But in that calculation, in that weighing, the curfew weighs such for me that tips the balance in crafting a RR release with the least onerous conditions. Having said that, to go beyond that, I don't have enough information on it, or it's enough been presented. So for those reasons, my curfew will stand as 6 p.m. to 6 a.m.
Thank you.
All right. School and work to home, home to school and work. All right.
Thank you.
Yep. All right. And that concludes our hearing.